place of correct law. The Custom and Excise Management Act, under which the facts alleged to constitute an offence in Cap 15, is punished or punishable. The offence in Cap 15 is consequently recognizable, and grounded in an extant existing law in Nigeria, in which it was defined and described. It is now on-book law that a charge preferred or filed for offence under a wrong law will not be rendered invalid or incompetent merely on that ground alone, so long as the offence on the charge are known to defined and punishable punishment provided for in an extant law. In the results, the answer to the answer posed earlier in this affirmative in both two counts, that the Terrorism Prevention Amendment Act 2013, under which the offences of count 1, 2, 3, 4, 5, and 8 as well as Cap C45 and Cap C45, Custom and Excise Management Act, all contained in Laws of Federation of Nigeria 2004, are extant and existing law, which provide for, under which the offences in the counts of the charge retained by the trial courts are punishable and punished. The offences, once more, are recognized, cognizable, and ground instant and existing law in force in Nigeria. Assuming without considering that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to Section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98.1. The Terrorism Prevention Act number 10, 2011 is repealed. 2. Any regulation, order, requirements, certificates, notice, direction, restrictions, authorizations, consents, applications, ongoing cases in courts, requests or things made, issued, given, or done under the Repealed Act shall, if in force at the commencement of this Act, continue to be in force and have effect as if made, issued, given, or done under the corresponding provision of this Act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or course of actions pending or existing immediately before the commencement of this Act under any of the repealed acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The import of this provision, particularly Section 98.3, is it serves as a saving provisions which ensure that the amendment of the Act does not affect the validity of trial begun under the Repealed Act. This saving clause or preservation provision is aimed at ensuring that pending proceedings or order of courts are not washed away as a result of the commencement of the amended Act 2022, but to ensure a smooth transition from the Repealed Act to the amended Act. The sum total of this is that The enactment of the Terrorism Prevention Amendment Act 2022 does not vitiate the trial of the defendant rightly commenced under the Terrorism Prevention Amendment Act 2013. Consequently,